Lady, I said we'd go to the Court of Appeal's judgment if that's convenient. With diffidence, obviously, I described the Court of Appeal's approach as to seek to rescue the tribunal's decision on this point. We've referred in our printed case to the case of Jaffrey in the Court of Appeal as to at least the jurisdiction of the Employment Appeals Tribunal. Namely that if error is made, the case should be remitted unless it can be said that the error is immaterial, or it can be said that although it's a material error, the appellate court can say what the result must have been. But certainly as far as the Employment Appeals Tribunal is concerned, Jaffrey goes on to say that the Employment Appeals Tribunal should not embark on a fact-finding exercise. Now, it may be that a more relaxed regime applies in the Court of Appeal, but in our submission, it would not be appropriate, as the Court of Appeal did, to seek to make for the Court of Appeal to seek to make its own findings of fact based on, again, I say this diffidently, what it thought the evidence was. And as the first point I want to make is that is ultimately the task on which, with great respect, the Master of the Rolls embarked. If you have in the core volume, MS page number 1062, paragraph 112, in my submission, the clue is in the last sentence. There was clear evidence as to the financial consequences of the van rental and of the telephone issued to operatives, and there was no need for the ET to refer to them specifically. So, again, I say all of this diffidently. There are no specific findings by the Employment Tribunal about the costs involved and or their implications in terms of the terms of the contract, but nevertheless the Court of Appeal was going to take a position on that. And if we then go back up to the beginning of paragraph 112, the Court of Appeal asserts that the evidence before the tribunal was clear and consistent. Now, one might gain the impression from that the Court of Appeal had sight of the evidence before the Employment Tribunal. If that is the impression gained, then it's a false impression. The Court of Appeal itself did not have, for example, the witness statements of the claimant or Mr. Scott Mullins. It had an extract from Mr. Mullins' statement which contained paragraph 40, because that was the paragraph on which the 36-hour working week was based. Nor did the Court of Appeal have documents from the tribunal bundle other than the manual and the contractual documents. And if one then goes into paragraph 12, again, I say this with diffidence, but one sees the risks in taking the position that one can reach evidential findings as an appellate court. And I laid the groundwork for this when we looked at the claimant's income and expenditure accounts. You can see that in this ninth line, in fact, the accounts of Mr. Smith. So the manual provided that the standard rate for rental of the van was £120 per month, plus VAT. In fact, the accounts of Mr. Smith, who only ever worked for PP, showed tax that his motor expenses were never less than £19,000. And in 3 of these years, more than £21,000. Now, the actual position, and again, I'm not asking you to make findings, I'm simply seeking to illustrate the risks of this type of approach. The actual position was that the rate at the material time was £140 per month, and therefore the vast majority of the vehicle expenses were accounted for by petrol, 140 plus VAT.
Not 120.
That's right. The manual it'd been updated to 140.
Oh, I see.
The vast majority of the expenses recorded in the accounts were therefore related to petrol, which, as I pointed out, was only an expense incurred if work was carried out.
Well, there'll be things like petrol, there would be, as you said, parking charges, there would be congestion charge, presumably.
Yeah.
Repairs, insurance.
Exactly.
Repairs, insurance, all
Exactly.
sorts of things, yeah.
Now, the reason I make the distinction is that what was being said in paragraph 12 as a foundation for the Court of Appeal's view was, well, if he's incurring costs, it must be implicit that there's a mutual obligation to offer and accept work because he needs to recoup the costs. Now, if you're looking at costs of in the order of £20,000, you can see the force of the point. But if the vast majority of those costs are actually only going to be incurred if he works, then you have to adopt a different evidential approach. You have to say, so what cost is he actually incurring whether or not he works? Now, I'm not asking you to make findings. I'm simply illustrating that absent findings from the tribunal, there were risks and pitfalls in the Court of Appeal without even sight of the witness statements or the documentary material before the tribunal, seeking to make its own findings about what the position was or was not.
Is there something in it, even if it's £120 a month? Quite a lot to carry.
Well, that's what I want to go on to deal with, because then the Master of the Rolls goes on to say the operative had to earn sufficient work assignments to be able to pay those expenses. And he says, presumably, to provide an income for Mr. Smith's ordinary living expenses. His case was that there would have to be a minimum of 36 hours per week. But again, I tell you this, I don't necessarily ask you to make findings, but the minimum rate was £80 per hour for general trades, of which the claimant would receive half. And that was for working between 8 and 6 in weekdays. If he worked in the evening, it was £130 per hour. So in terms of the amount of work that he would need to do to recoup the rental costs, it was in the order of 3.5 hours work in a week. If he did it in the evening, it was in the order of 2 hours. Now, those sorts of evidential questions in my submission needed to be thrashed out in the tribunal in order to reach a firm view about whether or not the level of costs was such that it was implicit that there would be mutual obligations as regards offering and accepting work. Working 36 hours per week would have taken the claimant very well beyond what he needed to do in order to recoup his costs, as I pointed out. The word presumably in my submission also highlights the exercise the Court of Appeal was embarked upon and the dangers of that exercise, because here one sees the Master of the Rolls making assumptions about what in fact lay behind the 36-hour figure. And then lastly, in relation to this, if the logic is that because he has incurred costs, he needs to work, then that points to an obligation to offer work rather than an obligation to carry out work. And of course, paragraph 39 had found in terms that there was no obligation to offer work.
If we're turning to something else, could I ask you to look briefly at paragraph 109 of the Master of the Rolls judgment? I'm sorry, this is a recapitulation of your submissions just prior to the short adjournment about the status of the manual after the 2009 contract.
Yes.
And can you see 7 lines down from the top of 109, both parties' cases were presented to the tribunal on the basis that the manual was still current and reflected the current relationship. Now, do you accept that your case was presented on that basis, Mr. Linden?
My client's case, because obviously I didn't appear on the scene
Of course not.
Appeal. I'm sorry, I wasn't being impertinent, but what I accept is as follows, that the agreed position was that as at 2005, the manual was incorporated.
Of course.
As at 2009, the submission to both parties accepted is, in other words, before the employment tribunal. As at 2009, I've submitted that both parties did not accept that the manual was current as regards the relevant obligation. I pointed out that the 2009 agreement did incorporate the manual, but in particular respects. And I pointed out that the respondent was actually arguing quite the opposite of what was stated in the manual, namely that clause 2.2 meant that there was no mutual obligation to offer and accept work, and the claimant himself was not saying there is an express term of the contract which provides for a 40-hour week. He was saying there is an implied term based on Mr. Mullen's concession that it's a 36-hour week.
So, Mr. Linden, I think you're saying that you don't accept that your case was presented on that broad basis, namely that the manual was still current after 2009. And if you don't accept it, this is a very unsatisfactory situation for us, isn't it?
Well, my Lord,
what are we to do about it?
well, my Lord, I am saying that we're talking now about the case presented before the tribunal.
Yes.
Yes. Now, I am, as you will appreciate, saying that the relevant part of the way the tribunal put it was that the relevant part of the manual reflected the reality of the obligations between the parties. And what I've demonstrated to you, and I don't think is actually disputed, was that in terms of the way it was argued, that clearly wasn't common ground between them. It wasn't the agreed position of the parties. One was saying nil and the other was saying 36. So I agree with respect that it's unsatisfactory, but and indeed rely on the unsatisfactory nature of the position, but possibly taking a different point to my lords, I say that is unsatisfactory because the ET has proceeded on a false basis, that there's an agreed position when there clearly wasn't.
You've certainly shown us that 47 in the ET
Yes.
is, you say, ill-founded.
Yes.
The other paragraph to which the Master of the Rolls there
Yes.
refers is 21,
Yes.
which I'm not sure we've looked at this morning.
Yes.
That's on page 8 of the
Yes.
internal numbering. ET 21.
Yeah.
Quite short.
Well, it
Last sentence says exactly what the Master of the Rolls
that's right. I'm not
adopts
disputing.
in the...
I'm not disputing that's what the tribunal said. But again, there is.
Say that's wrong as well, do you?
I beg your pardon.
Say that's wrong as well, do you?
Well, it's wrong and it's right. If I hate to sit on the fence, it's right in the sense that the 2009 agreement incorporated aspects of the manual that applied when the individual was carrying out their work, as I pointed out by reference to clause 2.6 and 3.2. So
I understand that, but that's not at all what is said in 21, is it?
well, it's possible, as it were, I use the phrase square the circle in our printed case, but it's possible to square the circuit in the sense that neither party was saying the manual has no application whatsoever. It's a completely irrelevant document. How could they when the agreement itself specifically referred to the manual in two places? But both parties were effectively agreed that the relevant part of the manual did not reflect the reality of the obligations between the parties as regards the minimum working week, as I've demonstrated, I hope, from this. So
okay,
you can reconcile the two positions, but what you can't do with respect is reconcile paragraph 47 with what you can see was quite clearly the respective positions of the parties on the reality of the obligations, using the phrase in paragraph 47, in relation to minimum working week.
Very well. I'm sorry to have taken you out
My
of
Lord, not at all.
turn.
Not at all. I hope my answer was helpful. So I was then going to go to paragraph 113, and I can take these points fairly briefly, but again, diffidently, I've suggested that the court sought to rewrite the tribunal's judgment, and the first respect in which I respectfully suggest that happened was that as far as paragraph 39 of the Employment Tribunal's reasons is concerned, in my submission, the tribunal plainly found that clause 2.2 reflected the reality of the obligations between the parties, and that therefore there was no obligation on the part of the respondent to offer work to Mr. Smith, the claimant, and that he himself accepted that, conceded in the course of his evidence. Now, if one then looks at what the Court of Appeal was saying at paragraph 113, 7 lines up from the bottom, Pimlico Plumbers did not have to offer him work if there was none to offer him, and Mr. Smith was not obliged to take on any particular assignment. Now, as far as the company's side of the equation is concerned, the Court of Appeal was therefore in our submission arriving at the opposite of what the Employment Tribunal said. In other words, the Court of Appeal was holding that far from it being the case that there was no obligation to offer work, in fact, there was an obligation to offer work if it was available. So I hope, with respect, it's not unfair to describe that as rewriting paragraph 39. Secondly, in our printed case, and I won't labour the points, we draw attention to the fact that there are serious issues as to the practicalities of the obligation on the company's side proposed by the Court of Appeal at paragraph 113. In particular, there were 125 operatives on the same terms, presumably therefore with the same right to be offered work on this analysis if it was available, all with different levels of availability and expertise. So enforcing such an obligation with respect threw up a number of practical difficulties and therefore pointed against the Court of Appeal's construction, particularly a construction reached without detailed findings as to the factual matrix. How feasible would this be in practice? If one then looks at the claimant side of the equation, the Court of Appeal took the position that although the Employment Tribunal and the claimant's submissions referred to offering and accepting work underlined, and although the claimant's case from start to finish was that it was a mutual obligation, 36 hours on each side, the position the Court of Appeal took was that it was to be offered if it was available. In other words, there was no guarantee. And on the claimant's side, he was to make himself available for the work, whether or not it was offered. Now, again, as a matter of construction, the court, looking at competing constructions allegedly based on common sense, in my submission, there are real difficulties with the notion that the contract should be construed as providing for such a one-sided bargain. The claimant only earned if he worked. The theoretical position, based on the Employment Tribunal's findings, was that he should hold himself available, in other words, turn away work, so that he had 40 hours of capacity, whether or not he would be offered any work. Now, not surprisingly, the claimant had never argued for that approach. He had always argued for mutuality, and indeed he had cross-appealed in the Employment Appeals Tribunal on the basis that it was paragraph 39 was wholly inconsistent with paragraph 47, because if he was under an obligation to accept work, surely he was effectively submitting the company must be under an obligation to provide it. Now, the claimants say in their printed case, unfortunately, there are such iniquitous contracts, and I accept that there are 0 hours contracts, the iniquity of which is that the employer can insist on the individual being held available to work without promising any work to that individual. And there have been increasing moves to regulate such contracts. But that, with respect, doesn't meet the point that if the issue is the interpretation of the contract reached between the parties, and the law tells us that the competing constructions have to be assessed against whether they make business sense and the likelihood that either party would have entered into such an agreement, in my submission, it's a powerful point to say that it can't have been an agreement, that the claimant would simply hold himself available. And that's why the claimant himself had never argued for it. Again, as to construction, there were in our submission, serious practical issues in relation to the proposal that the claimant simply held himself available. The tribunal, as you appreciate, found that he was free to decide his hours, and he was free to decide whether he took a given job. And we submit that it's highly doubtful as to how that could be reconciled with an obligation to hold himself available for a minimum 40-hour week. How would it be decided that the point had now been reached in the week where his previous obligation or his previous right to turn away work, now had vanished and had been replaced by an obligation to accept work and to perform 40 hours of it. So these submissions are essentially directed at saying the Court of Appeal should not have embarked on its own fact-finding exercise, and secondly, the construction that it reached as a consequence was, in my submission, implausible, to say the least. What it should have done is remit the matter. Now, apart from the points that I've made in relation to the question of the duty to offer work and the availability, the claimant holding himself available, Lord Justice Underhill, as you've seen, at paragraph 138, adopted a route which was essentially to say, well, there are conflicting and inconsistent contractual documents. The task of the court is to reconcile them, and this is how they may be reconciled. You've got my submission, which is essentially to the fact that they were not conflicting. There was no conflict. The relevant parts of the manual were incorporated. The material parts for present purposes were not. There was no inconsistency, and in any event, see the principle we saw in Sir Kim Lewison's book. So our final submission is on this point is that if, therefore, it was appropriate to reach a construction of clause 2.2, the clause should be interpreted as drafted. I put it in those terms, and that section 2 of the contract is all about making provision for the parties to agree, if they choose to do so, to periods of work. I accept that it was anticipated that they would do so. I accept that it was expected that they would do so. But the contract did not create an obligation to do so.
Justice Underhill at 138, as you I think point out, is concluding, isn't he, that in order to make sense of the documents as a whole, the position required Mr. Smith to do, as he puts it, in substance, a full week's work, at least if the work was available to give him. And now you've, I think, submitted that the effect of 113, which of course is the master of the rolls, is to conclude that the contract was a 0 hours contract where there's an obligation to hold yourself available whether there's work or not.
Yes.
Is that a necessary implication of 113, do you say? Or is it consistent with the rather important words in brackets in Lord Justice Underhill's judgment at 138?
Michael, would you be kind enough to just point out
It's
the various words?
It's at least if work was available to give him, is the point.
Yes.
Which prevents it being a 0 hours contract, doesn't it? You've still got to get over 2.2, that I understand, but this is a separate point.
My Lord, I'm not suggesting there's any difference in the approach of either the Master of the Rolls or Lord Justice Underhill. What I'm submitting is that on the company's side, whereas the Employment Tribunal had held that there genuinely was no obligation to offer work, the Court of Appeal held that there was an obligation to offer work if it was available. And then on the claimant side, whereas the Employment Tribunal held at paragraph 47 that there was a minimum working week in the sense of doing work, the Court of Appeal held that it was that the obligation was really an obligation to be available for work. And you've got my submission on the plausibility of that construction. So last point in my submission on this issue, and then I'll come on to the third issue. In my submission, there was no reason why clause 2.2 should not be construed in the way that we contend for, that work was to be done on an as-agreed basis. It's a perfectly plausible reading of the term and entirely consistent with the language of the term. Now, if we're right on this point, my submission is that the relief should be that the matter should be remitted on the basis that there was, for the tribunal to consider the status issue, on the basis that there was no mutual obligation to offer and accept work. In other words, you should hold in the company's favour on the interpretation of clause 2.2. You may be thinking, well, is he not being inconsistent? Because he said, well, you've got to remit as regards issue 1 so that the contract can be construed within the factual matrix. My answer is we're not being inconsistent. The situation, as you've seen, is that the claimant contended for a 36-hour minimum working week. That was his case before the tribunal.
Well, it was his argument,
Yes,
or the council's argument.
yes.
We've no idea what Mr. Smith actually said, I don't think, have we?
Well, I'm not going to go through all the documents with you now, but it's, in fairness, I'll point out that he did initially plead that he was subject to a 5-day week. That was then disputed in evidence by the respondent, and what emerged at the end of the case was the arguments that you've seen. But the point I'm making on remittal is, well, the 36-hour minimum working week, which was ultimately the case put on the claimant's behalf to the tribunal, was unsound for the reasons I've given, but of course the Court of Appeal also held that it was unsound, and there's been no attempt to challenge that at the moment. So my submission is that he shouldn't have a second bite of the cherry. Can I turn then to the third issue, the assessment point? Can I start by going to the James and Redcats case, which you've got in Volume 2 at tab 29, Volume 2 of the authorities. Tab 29, and if I can ask you to turn up MS 417. We've seen already, when looking at Winkelhoff, paragraph 48, we've seen reference to Mr. Justice Elias's comments on the Cotswold construction case. So, again in Winkelhoff, paragraph 50 is the comment on it, that it will often assist, but there are difficult cases where the worker doesn't market his services at all. And then this, nor act for any other customer, even though the claimant is not barred by contract from doing so. In some cases, the business is effectively created by the contract. And then at 51, Mr. Stafford made a submission that the individual must have been in a pre-existing business, and that was rejected. At para 68, just for your note, there is further emphasis on the point that we've sought to emphasise in our submissions, that the assessment of the relationship created by virtue of the contract, using the language of the section, requires a careful analysis of the elements of the relationship, and there is no shortcut to a considered assessment of all relevant factors. However, in some cases, the application of the dominant purpose test may help tribunals to decide. Maybe then go back into the employment tribunal decision and take it up at core volume MS 1035. Sorry, if you wouldn't mind starting with 1031, you've seen at 1031, 1032, the passage on which Mr. Justice Elias commented in James from the Cotswold case, which was actually Mr. Justice Langstaff, is cited at length by the Employment Tribunal.
At 36, is it?
That's right, 36. And you've seen that there's no reference at all in the judgment to the James case, although the case was cited to the tribunal. And then going to paragraph 53, in our submission, what you can see is the tribunal firmly applying the Cotswold development approach in a what we would submit as an unqualified way. So you can see that the first respondent could not be considered to be a client or customer of the claimant's business, but it's clearly better regarded as a principle of reference to an integral part. So it's paragraph 53 at MS 1035. Integral part of the first respondent and subordinate to the first respondent. The claimant did not work for anyone other than the first respondent, and there is no evidence he sought to do so or marketed his services. So the first point we make is that the Cotswold development approach was, as you've seen, qualified by in the James case. James was cited, but one doesn't see any reference to the tribunal having that qualification in mind, the question of marketing services to the world. You can see also at paragraph 53 that the tribunal relied on the question, on the point that the claimant worked solely for the first respondent, but did not point out that that was not pursuant to any contractual obligation of exclusive service. And as you've seen when we looked at Winkelhoff, that was a key feature of the Westwood and the Winkelhoff cases. Now, in this connection, may we go into volume 3 and look at more material from Professor Attia on the subject of exclusive service. That's at tab 54 of volume 3, MS 839. Sorry, it's volume 3 of the authorities. Tab 54, MS 839.
Thank you very much indeed.
No, it's my fault, my lord. So under the heading Master's Right to Exclusive Services of the Servant, there's a point for me and a point against me, and I'll draw your attention to both. Just halfway down the page, you can see, nevertheless, it cannot be said that this fact of those exclusive service can often be considered of vital significance, especially in dealing with persons who are normally considered to be independent contractors. For example, an author who makes his living by writing novels could hardly be treated as working under a contract of service merely because he undertakes to offer all his books to one publisher. Moreover, the mere fact that over a lengthy period of time a person has in fact worked exclusively for one employer is of no significance if there is no evidence that he's under any obligation to do so. And you've seen that in our printed case, we make the submission that if I appreciate there's a degree of circularity to this, but if an individual or a business is an independent provider of services and under no contractual obligation to work exclusively for the recipient of the services, it would be surprising if the fact that they then voluntarily provide services frequently to the recipient of the services changes the status of the independent provider of services to a worker. And that's essentially the point that Professor Attia is making, albeit here in the context of a contract for service, I accept. But the logic is the same. If you voluntarily trade on a regular basis with a particular customer, it doesn't stop you from being an independent trader. Now that's the point for me. It's then illustrated. So in Humberston, where it was shown that a plaintiff lorry driver owned his own lorry, worked exclusively for the respondents, the Australian High Court held in the absence of evidence that he was contractually bound to do the work, the mere fact of his having rendered exclusive services of no importance. But however that may be, it seems doubtful how far any legitimate inference can be drawn from the converse situation, i.e. a case where the employer is not entitled to the exclusive services of the person in question. In the absence of express contractual provision, it's only exceptionally that a master is entitled to claim the exclusive services of his servant, and he has therefore no complaint merely because the servant works for someone else in his own time.
Mr. Hend, I'm having some difficulty
Yes.
in understanding the relevance to this appeal of quotations from a book written by a very, very distinguished legal scholar in 1967, before there was any question of a limby worker or an employee within the meaning of the Equality Act.
Well,
So all of these things are about what the difference is between an employee or a contract of service and everybody else.
yeah.
It's an interesting blast from the past for those of us who were brought up on it here, but it is a very long time ago.
Well,
But you simply say that the examples stand.
well, let me try and answer Lady Hale's question. I acknowledged, didn't I, that this is about contracts for service.
You did acknowledge that, but
Yes.
I was merely tweaking your tail.
Not at all. But I'm looking at the passages, and I'm submitting that they support the argument that we've made. That I've accepted that the worker concept is wider than the contract of service point. But I've also pointed out in the course of our arguments, by reference to the case law, that essentially what the court is concerned to do is to distinguish between independent providers of services and those who are in broad terms an employment relationship. And I submit that the same logic applies in the present case, and I sought to make the point that if you trade on a regular basis but voluntarily, it doesn't mean that you suddenly become a worker. And I'm conversely accepting, against myself, that the same logic as Professor Attia sets out, that the absence of exclusivity of service is a neutral factor, again appears with respect to Professor Attia to be logically sound. Now, if one asks then, so what did the tribunal do wrong? That's no doubt you're asking yourselves. In relation to this particular factor, what the tribunal does is rely on what I submit is a neutral factor, namely the fact of frequent work, without acknowledging that there was no obligation of exclusive service. Nextly, you can see that the tribunal relies on subordination, as to which you've seen what this court said, endorsing James and Redcats, as to the extent to which that assists, and that's again a paragraph 53. Nextly, by way of complaint about the tribunal's assessment, what one doesn't see in the section dealing with the status question is any reference to the factors which pointed towards independent contractor status, simply consideration of the factors which the tribunal identified, mainly based on Cotswold developments, which pointed away from it. Now, as to the question, what were those factors? If we're right on issue 2, the minimum working week, one of the factors was that there was in fact no obligation to offer or accept work. Secondly, drawing on the case law that we've seen in relation to financial risk, what one doesn't see in this section of the tribunal's judgment is the tribunal weighing that consideration. And this was a case, as you've seen, where there was significant financial risk for the claimant, because when he accepted a job, he quoted for it based on how long he estimated it would take, what materials were required, whether he needed to engage assistants, and so on. And he therefore took the financial risk that if the job took longer or the materials cost more or weren't needed, or the labour costs were higher, or that the customer didn't pay, as you've seen, And conversely, he was able to make a profit from the job if he could negotiate a fixed price, I accept, at hourly rates decided by the company, and he was then able to do it cheaper. So in my submission, clearly that was something the tribunal needed to consider quite carefully, the fact that there was significant financial risk in terms of the way that the claimant dealt with a particular job which he had agreed to carry out. Nextly, the tribunal doesn't refer in this connection to the fact that the claimant agreed to be responsible for the completion of the task, whether he himself carried it out, or assistants did so, or substitutes did so, nor does it refer to the fact that he was obliged to make good any deficiencies in the work at his own expense. Nextly, the tribunal nowhere refers to the fact, in this, at least in this section of the judgment, that he was able to engage assistants at his own expense to complete the job, which, as I've sought to submit, points strongly towards independent contractor status, see Hill and Beckett. Nextly, in terms of financial risk and the ability to make profit, in this section of the judgment, the tribunal does not refer to the fact that he was entitled to charge a markup for materials, 20% if the cost of the materials was above £3,000, 12.5% if it was below. Nextly, one does not see in this section of the judgment the figures that we saw in Appendix 2, the claimant's income and expenditure account, identifying costs that, for things that one would associate with an undertaking. Not just his own tools and equipment, clothing and insurance, etc., but also secretarial office costs, internet and stationery and so on. And then finally, one doesn't see the tribunal evaluating the fact that the claimant had a high degree of autonomy, as we submit, in terms of whether he accepted a job, and then when and how it was to be done.
Was the tribunal entitled to take into account the contribution that the person made to the enterprise being run by, in this case, the plumbers firm?
Well, in what
Well, we've been looking very much at what risk he took financially,
Yes.
what his bottom line would be with after his expenses and so on. Was the tribunal entitled, in looking to see whether he was a worker for that business or not, at the contribution he made to their profit? What made me think about it was the fact that if the invoice remained unpaid for over a month,
Yes.
he got nothing.
Yes,
So he took the risk,
yes.
and if it was then paid, they took the profit. Was that relevant?
Melody, yes, I accept that it was.
Was it in the deliberation of either the tribunal or the Court of Appeal?
It was in the employment tribunal. The employment tribunal did make a finding about that. Yes.
Yes, but was it put into the balance? I'm asking you whether it can be put into the balance.
No, I take that there wasn't. No balance was carried out.
Okay.
That's my.
So it was relevant to the balance, but not
In my submission,
put in.
it's relevant. It goes to financial risk, and as to your point about is he contributing to the business, again, I wouldn't say that's completely irrelevant, but it still begs the question of independent provider of services or not, because of course you can have two people running a business together.
Yes.
Now,
It shows strong control over remuneration.
I beg your pardon, my lord.
It shows strong control
Yes.
over remuneration.
Yes.
Well, not only in respect of what he was allowed to charge for each hour of work that he completed, but also the markup he was allowed to charge on the materials that he'd bought himself.
Yes, and I agree that those factors point against independence.
Personally, to myself, I think I can see the point that you're making, that what is required is an overall assessment. It takes us back to whoever it was who said there's no single key to the difference between a worker and an independent contractor. So you've got, and you've given us a list of things that aren't referred to.
Yes.
Got all those, I think I can see that. But whether or not there are flaws in it, what is the employment judge doing at 53?
In my submission, applying Cotswold developments.
Well, she's asking herself the statutory question, isn't she?
Yes, but, that's a reference to the first sentence.
It is, yes.
Yes, but
And the answer is, without certainly listing the factors, and that may or may not be fatal, we'll have to think about that, but is she not asking herself, looking at this relationship, can Pimlico Plumbers realistically be said to be a client or a customer of Mr. Smith? Or are they the principals of which for whom he is acting? And is there anything wrong with that as a question?
well, insofar as it reflects the statutory definition, obviously not. Can I respond
Please.
slightly more deeply? But as it were, 2 points. One, in the case law, as you've probably gathered, the courts have found it difficult to say what it is that you should be looking at when you seek to answer the statutory question. And we've seen, helpfully in Winkelhoff and Westwood, that there is no single key. But you've also seen that the cases have said, of course, this type of, you've got Cotswold saying this should be the focus, and we say that was the tribunal's focus. But James saying, but actually focusing on subordination and or whether they market their services to the world in general, in some cases, and in particular cases like this, will not necessarily be of assistance. So our first basic complaint is, in terms of the tribunal's evaluation of the statutory question, which I accept is identified in paragraph 53, one does not see the tribunal with showing an appreciation of the different approaches identified in the case law. And from our point of view, importantly, one doesn't see the qualification of Cotswold development set out in James, although that was specifically pointed to by the respondents before the tribunal. Now, so it's easy to say, well, the tribunal must have had it in mind, but in my submission, that's a surprising suggestion when one sees that what the tribunal actually did was refer in detail and at length to Cotswold developments, not just at 36, but also at paragraph 30, MS 1030. And if the tribunal had it in mind, it's very surprising that it did not refer in, at least mention, let alone refer in similar levels of detail, to the important points that were made by Mr. Justice Elias, as he then was in the James case. So that's our first point. As to those nuances and qualifications were not anywhere mentioned by the tribunal, and I respectfully submit that's a sign that the tribunal didn't have them in mind. The second point, in answer to your question, I'm sorry it's such a long answer, but I've nearly finished, is moreover, the cases are saying there's no substitute for a careful assessment. Now, it's easy in responding to this type of appeal. I'm sure Ms. Monahan will say it perfectly properly. Well, they must have had it in mind. It was in the evidence and or it's in their earlier findings. But it's much easier to sustain that proposition if they've clearly identified what they should be looking for in the case law, which I say they haven't, and then perhaps set out some of the countervailing considerations, which in my submission they obviously haven't. Now, the analysis that I propose is that what really happened in this case is that the tribunal spent significant time on personal service and the minimum working week. It then thought, as we've submitted in relation to issue 2, well, if they've got an obligation to do 40 hours a week minimum or 36 hours per week minimum, that points very strongly to employed status. No need to spend very much time on the status question because it's almost answered itself at that stage of the reasoning. And there is therefore, as we put it, a straight application of Cotswold developments, but we submit that isn't sufficient given the case law that you've been taken to.
It's quite a long time since people talked about industrial juries in the employment tribunal, but you do say, do you, that asking yourself the jury question, the relationship between Mr. Smith and Pimlico Plumbers looks like a relationship of independent contractor and client?
Well, I'm not asking you to decide that. I mean, we're, as I said, had to keep saying to
Well, no, what the real question is whether the employment tribunal is entitled to come to the opposite conclusion.
exactly, and I'd accepted that. My submission is that the tribunal got it wrong in the three respects
Yes,
that I
okay.
sought to persuade you on.
All right.
But if I'm right on even one of those, my submission is that the consequence should be that the matter is remitted. I don't invite you to say, well, we will evaluate the facts. I've just spent time criticising the Court of Appeal for doing that. I invite you to say the matter's got to go back. That it's simply wrong on personal service, wrong on the minimum working week, and wrong on its approach to the assessment of the status question.
The note I ought to make is that they certainly could have concluded that any sensible juror would have said this is a client entrepreneur relationship.
Well, this is a judge alone, obviously, but it may not matter.
No.
I can't say that it would be impossible to conclude. You should say, in this case, it would be impossible to reach the conclusion that Mr. Smith was a worker or an Equality Act employee. All I argue for is that if that conclusion is to be reached, it be reached on a sound legal basis. And my submission is, for the reasons that I've given, that it wasn't. And I don't say that, well, that's the end for Mr. Smith. I say, therefore, let it go back and be done on a sound legal basis. Is there anything else? Melody, those are our submissions, unless there's anything else you wish me to address.
You've had quite a lot of questions addressed to you. Thank you very much,
pleasure
Mr.
answering.
Linden. Thank you. Yes. Mr. Norbert?
My lady, my lords, I am going to start with purpose and context. Mr. Linden said to you in his submissions that our case on this issue was put passionately. I would like to say properly rather than passionately. So far as the claimant's broad contextual submission is concerned, we invite the court to remind themselves that as to the working time regulations, which is the first part of the claimant's claim, so although we focused on the Lim B test, in fact the substantive claim is brought under the working time regulations. Definition of employment is exactly the same as Lim B. The reason that the Employment Rights Act and the Lim B test has been a focus is because there is an unlawful deduction from wages claim arising from the fact that holiday wasn't paid. So the Employment Rights Act deals with unlawful deductions from wages and includes Lim B workers. The working time regulations identify what hours and holidays should be paid for and adopt the same meaning of worker as in Lim B. The importance of highlighting that particular point, that is that the focus of the claim is on the working time regulations, come to the Equality Act in one moment, is to emphasise the importance of those regulations. They concern health and safety, quality of life and dignity at work. Excessive working hours are dangerous and they undermine workers' dignity while working. So they are very important and there's no warrant for construing their scope more narrowly than the terms of the provisions demand, and I'll come to what EU law says about that in due course. Secondly, as to the Equality Act, the importance of non-discrimination both domestically and at EU level cannot be overstated. Your ladyship and your lordships will be very familiar with the fact that in the domestic context, we've had anti-discrimination legislation in the employment sphere now for 50 years in one form or another, well before EU law, and I'll come back to that too in one moment. But anti-discrimination rights are both fundamental here and as a matter of EU law. As to those rights, I would like to take you to one case on purpose Can I ask, please, that you take up volume 1 of the authorities, tab 16, and turn to MS 164. MS 164, tab 16. This was a vicarious liability claim brought under the Race Relations Act. The definition of vicarious liability is in identical terms now. If you look at the bottom, please, of the facts in the head note, you'll see in summary that the test for vicarious liability was whether or not the act done was in the course of employment. The court had to ask itself whether the test for determining vicarious liability ought to be the common law test, that is, was the act authorised, or was it an unauthorised mode of doing an authorised act? If so, vicarious liability; if not, no vicarious liability. The difficulty posed by the facts of this case was that the abuse was extreme. So if we look at page 256 of the report and 166 of the memory stick numbering, MS 166, bottom of the last paragraph, G to H, the employee gave evidence of ill treatment, both physical and verbal, of 2 fellow last operatives called Clements and Cotter. The physical incidents consisted of burning his arm with a hot screwdriver, whipping him on the legs. This was a young black worker. Whipping him on the legs with a piece of welt, throwing metal bolts at him and trying to put his arm in a lasting machine. The verbal incidents consisted of calling him chimp, monkey and baboon. The employee reported the burning incident to his supervisor, who moved him to another part of the factory, but there were further incidents. And so it was said on behalf of the employer, well, vicarious liability can't possibly attach to those acts because on no analysis could those be said to be acts that were authorised or an unauthorised mode of doing authorised acts. As to the approach the Court of Appeal took, and it's a well-known passage, but it's worth restating in my submission. At page 262 of the report, at page 172, this is in relation to race and sex discrimination, but applies equally to disability, with which we're concerned now. So to page 262, next to letter B, the legislation now represented by the Race and Sex Discrimination Acts currently in force broke new ground in seeking to work upon the minds of men and women and thus affect their attitude to the social consequences of difference between sexes or skin colour. Its general thrust was educative, persuasive and, where necessary, coercive, and deals with the wide relief available. And then next to D, consistently with the broad front on which it operates, the legislation has traditionally been given a wide interpretation, citing Lord Justice Templeman in Savjani. And then moving down, since the getting and losing of work and the daily functioning of the workplace are prime areas for potential discrimination of grounds of race or sex, it's not surprising that both acts contain specific provisions governing the field of employment. The provisions are themselves wide-ranging, as is evidenced by the inclusion of contract workers without employee status within the scheme. And there's no indication that when dealing with the employment field, Parliament intended in any way to limit the general thrust of the legislation, and then indicated that a purposive construction had to be given, course of employment in the ordinary meaning, that is, common sense meaning, and vicarious liability was established. Now, I draw attention to that simply to emphasise that there is no warrant to giving a narrow reach to the terms of the Equality Act, beyond that which the language of the Act compels. I accept that ultimately the test is one of law. That is, policy won't be a complete answer. But when looking at meaning, policy must be had regard to. And if I can start with one illustration about how common sense and the Equality Act, or the non-discrimination provisions, might sometimes seem to be counterintuitive. My lady, you asked this morning about barristers. If I understood the question you were asking, and if I didn't, then I hope you'll forgive me, but if I understood the question you were asking of Mr. Linden, you were exploring whether or not barristers were independent workers or fell within the wide scope of employment for the purposes of the Equality Act. Did I understand the question? Exploring.
Carry on to make your point.
Okay. Exploring the possibility that barristers couldn't be caught by that wide definition because we are carrying on business by ourselves, we market ourselves, we have autonomy, and so on. In fact, barristers are covered in terms by the Equality Act, so a solicitor cannot refuse to instruct me because I'm a woman. However, that may be simply Parliament's choice, and one can say, well, what's that got to do with anything? That's a policy decision. Well, in fact, we know that the provisions addressing discrimination against barristers were amended post the Race Directive and the other directives to give effect to those directives, and they were amended pursuant to the European Communities Act on the basis that it was assumed, and hasn't been challenged, that the requirement to outlaw discrimination in the sphere of occupation under the directive was broad enough to embrace barristers. Now, I appreciate that Bates, X, and Givraj are all against me on that, and I realise that, and I hope I've said with a degree of diffidence and I think circumspection in the case, that we recognise that we cannot go behind those, but it's important, my lady, to ensure the bar is not set any higher. I don't know whether the Race Directive and the history of the amendments under the Act were referred to in Bates and Givraj and so on. I can't know.
I wasn't in Givraj, so I don't know, and I don't remember it in Bates, but there we go.
There we are. There's, as I say, it was certainly anticipated that occupation went as far, at least, as barristers. So one can't make assumptions about scope based on common sense, purposive and broad, we say. As to the Employment Rights Act and the working time regulations then, we also draw attention, in having regard to the policy context, to keep an eye on reality. This is not an auto-cleanse case in the sense that the Employment Tribunal and the Court of Appeal did not consider it necessary to treat any of the provisions of the contractual documents as a sham or a device for evading the employment legislation. But the observations made in auto-cleanse are very important when one stands back, looks holistically, as you're invited to do by Mr. Linden and will be by me, when you stand back and when the tribunal stands back and asks whether or not this is truly an independent contractor with Pimlico Plumbers as his client, or whether it's a worker relationship. And if I can ask you please just to turn to auto-cleanse, volume 2 of the authorities, tab 35, MS 485, tab 35, MS 485. And please, 494, MS 494. Paragraph 29 at the top of the page, I beg your pardon, paragraph 26, forgive me, 494, paragraph 26, citing there Mr. Justice Elias in Calwac, having identified already the danger that's posed by lawyers. Paragraph 59, tribunals should take a robust view of these matters to prevent form undermining substance. And then Calwac again, provingly at paragraph 30. In paragraph 57 of Calwac, Mr. Justice Elias quoted Lord Justice Peter Gibson's reference to the importance of looking at the reality of the obligations and to the reality of the situation. And Lady Justice Smith, the kernel of all these dicta is that the court or tribunal has to consider whether or not the words of the written contract represent true intentions and expectations. And then moving down again, references to reality and at paragraph 34, Lord Clark over the page at 496, citing Lord Justice Akins, who observes that contracts in the employment sphere are different to those in the commercial sphere, identifying inequality of bargaining power as a key context. And the last line of that indented quotation, tribunal must be realistic and worldly wise. So looking at these, standing back, being worldly wise, and in that context, my lady and my lords, my ladies and my lords, I have to get used to saying that, my ladies and my lords, in that context, I also invite this court to be mindful of the fact that here was a specialist tribunal and an specialist appellate tribunal. This is a third-tier appellate court for these purposes. First tribunal, second tribunal specialists. Every day they will be dealing with status claims, every week. Certainly the tribunals deal with them endlessly. Tribunals know what the labour market looks like. They know what workers look like. And whilst I can't say deference should be shown to their decision, at least regard should be had to the fact that they're specialists in this field. As to then the substantive legal points, firstly, substitution. We say that it's only in the case of a truly unfettered right of substitution that the necessary requirement that work be performed personally is missing. A limited right, as the authorities make clear, isn't inconsistent with the obligation of personal performance. And if I can please take you to an early case, Volume 1, Tab 9, MS 1055, sorry, beg your pardon, MS 60, I beg your pardon, Tab 9, MS 42, MS 60, sorry, Tab 9, Volume 1. This is an employment case, a contract of service case. I shall probably say more than once that it's important in my respectful submission not to align the concept of employment with that of worker, but I show you this case only because even within the context of the much stricter requirements for a contract of service, there is nothing inherently problematic about some delegation or substitution. So if I can ask you please to look at page 60, MS 60, MS 60, which is at the internal report, page 515, internal numbering 515, letter C. I must now consider what's meant by a contract of service, the narrow version. Contracting service exists if these conditions, servant agrees that in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some service for his master. He agrees that it will be under their control, and the other provisions are consistent. I need say little about 1 and 2, as to, I think that must be 2. There's obviously a typographical error there, because they do then talk about 1, which is personal service. As to 1, there must be a wage or other remuneration, otherwise there'll be no consideration, and without consideration, no contract. The servant must be obliged to provide his own work and skill. Freedom to do a job either by one's own hands or by another's is inconsistent with a contract of service, though a limited or occasional power of delegation may not be. So even in the case of a contract of service, a requirement for personal service, an obligation to be under the control of your master, your employer, even then, the power in the hands of the employee to delegate is not by itself necessarily inconsistent with the right, with employment status. So that's by way of introductory observation. If I can also please ask you, recall the observations made by Mr. Linden about where the line is drawn so far as personal service is concerned. That is, if one is unwilling to work and has a power to delegate or substitute, is that necessarily inconsistent with an obligation to provide service personally, as opposed to a power to substitute or delegate only where one is unable to work? So you'll recall Mr. Linden drew a distinction between those two circumstances and said where you can substitute simply because you're unwilling, that negates any obligation to provide personal service and is inconsistent, therefore, both with worker status and employee status. We say that's too simplistic and overstates it, not least because where the line is drawn between unable and unwilling will often be impossible to discern, or at least become over-pedantic. If I decide to delegate a task so I can see my grandchild in the school play, is that because I'm unwilling to work or unable to work? Those are distinctions without principle, and they are, in my respectful submission, not workable in the context of employment. As to assistance, because we heard too about the opportunity in this case for the claimant to engage assistance, and I'll come to the manual in due course and what the contractual documents say about that, but I emphasise too that even in the case of employment in the narrow sense, the right to engage assistance is not inconsistent with the obligation to provide personal service. And if I can ask you please to look at Volume 1, Tab 11, Volume 1, Tab 11, MS 87. This is the gunning case, which we've already looked at, but I don't think we looked at this section, and if we did, I hope I'll be forgiven. If we look at, this was the wholesale distribution agent, you'll recall, and if I can ask you please to look at MS 98, which is 156 of the internal numbering. In fact, I think we may have looked at this. I beg your pardon, I can see I've flagged it. So this is the observation by the court, Lord Justice Balcombe, that the fact that one might secure assistance, the plumber, for example, very apposite, the plumber who might be expected to have a mate, here a labourer as it's described under the contractual documents that I'll come to, not inconsistent with the requirement to provide personal service. So delegation by itself isn't. No principled basis, we say, for distinguishing between unable and unwilling. And assistance as well, not inconsistent with an employment contract of service, the much narrower, more strict test that applies. As to Halawi, which I may as well take now, I think my Lord Hughes asked the question, was there a relationship between the person who was coming in as the substitute and the putative employer? The answer is no, because these arrangements were done through companies. They were incorporated. So the claimant contracted through her own company, and so there was an arm's length arrangement, not in the nature of a worker, but an arm's length relationship, and that applied equally, as we understand it, to those who came in as substitutes. So while they might have had to have the consent of the putative employer, there was no direct relationship between the worker and the employer. They were all
Well, I did ask the question, but what I've been wondering about, and the reason why I asked it, was whether it makes any difference. And if it makes any difference, why?
Well, I think that it makes a difference in this sense, from our point of view. Our primary point is substitution is consistent with personal service unless it's utterly unfettered, because then, of course, there's no requirement to do any work. But to the extent that the court thinks otherwise, then there are distinguishing features in that case which pointed against personal service in any event. There was an arm's length arrangement, both with the substitute and with the putative employee or worker. So it was a very different class of case, not a case where somebody is required to do personal service, undertake personal service in a single contract between worker and employer, and chooses to substitute for another, but a person who's employed by a third company through an arrangement with the putative employer. So a very different class of case, a very different class of case. Still on the Employment Rights Act and the Working Time Regulations, in addition to personal service, of course, I'll come to mutuality of obligation in a moment, but in addition to personal service, there were a number of other factors identified in Bates, for example, or Winkelhoff. I won't take you back to them. I will when we come to the facts in due course, which I think will be tomorrow now. But I remind the court that there are a number of factors. They're not mutually exclusive. They haven't been overtaken by more recent case law. They are factors which together point towards or against the existence of a worker relationship. And they include the extent to which the worker is integrated in the business. Come to that, very important here. degree of dependence, dominant purpose, and the degree to which they hold themselves out, marketing in the open marketplace. All of those are important in this case. But in addition, there's no single lock or magic ingredient, as already has been observed. And so there is a standing back and looking holistically and asking oneself, is this really a worker relationship? Or is this worker, or putative worker, acting on their own account with, in this case, Pimlico Plumbers as a client or customer? I'll come back to the facts, but as Mr. Linden properly says, there's no dispute in essence about the factors that the court should have had regard to, and we say did have regard to. The next important matter, still under the Employment Rights Act and the Working Time Regulations, concerns the issue of mutuality of obligations. That's a matter too touched upon in the context of the Equality Act. As to mutuality of obligation, we say that there was mutuality of obligation here based on what we say are the unimpeachable findings of the Employment Tribunal. I'll come back to those in due course. But we also say, in terms of the legal principles, that, of course, mutuality of obligation is not relevant at all during the currency of an assignment. That's accepted by Mr. Linden. So while you are doing the job, the task, mutuality of obligation is neither here nor there. You are doing the task, you are engaged.
Well, it's obvious, it's there.
It's there. It's there.
Yes, it's not that it's not relevant.
It's there. Sorry,
it's inevitable.
It's inevitable.
All it means is you have to have mutuality of obligation, as I think Justice Langstaff said ages ago, in order to have a contract.
Precisely.
Yes.
Precisely. So when I say it's irrelevant, it's not. When I say it's not relevant, what I mean is, insofar as once the assignment is being undertaken, one doesn't need to go any further than that. The answer's clear. Mutuality of obligation, we say, is only relevant where it's necessary to link the assignments, usually for the purposes of continuity. So where one wants to establish a claim in unfair dismissal, for example, they will need to show that they have 2 years service, and they will want to show, therefore, that as between assignments, there was the requisite mutuality of obligation. However, we do say that Windle elevates the question of mutuality of obligation to a level that isn't justified, in particular where one is not seeking continuity, because it assumes that mutuality of obligation will be relevant to status, that is, independent contractor or worker, because it's indicative of subordination. We have made the point in our case, and I emphasize it, that the absence of mutuality of obligation is just as likely to show vulnerability and subordination as is the existence of it. And if I can take you, please, to City Sprint, just to illustrate this. It's a first instance decision. Volume 3 of the Authorities, tab 53. And the MS number is 812. This was a cycle courier case. And if I can ask, please, that you turn up page 813 in the first instance. One can see at 813 the broad terms of the contract outlined, and under paragraph 8, 2.31, contractor agrees and warrants that he's self-employed during the 3.1, during the term of the agreement where the contractor agrees to undertake a job. The contractor will comply with the job details. 3.4, contractor shall advise City Sprint on the days they're not available. And then finishing off on that, in that paragraph, advise on what contractor is not available to accept jobs, and on such days when the contractor is available, the contractor shall advise City Sprint if at any time on that day he no longer wishes to undertake jobs. City Sprint has no obligation to offer the contractor work at any time, and the contractor has no obligation to accept work at any particular time. And if I can now, same case, turn to page MS 822. Paragraph 49. It's a very experienced employment judge. Paragraph 49. Choice to work when on circuit. Once on circuit and logged on, a courier will only say no to a job for a good reason. Mr. Baker confirmed that there was an expectation when couriers logged on that was when they wanted to work. This is invariably the case, which again makes good business sense. Mr. Turner was unable to give examples about how he picks and chooses work when logged on, but he put it down to professionalism. Mr. Dewhurst, claimant, was also proud of her professionalism, but did describe one incident where she was feeling unwell at the end of the day and asked the controller if she could go home. She was told that he could not find somebody else, and so she could not go. The respondent did not provide evidence to rebut this. She accepted this instruction because she thought it was her obligation, and she feared not being given more work if she refused. This is inequality in bargaining power at work. No obligation, but you don't do it, and you won't get any work from us. So the absence of obligation, the absence of mutuality of obligation during the gaps between assignments is just as indicative of vulnerability, just as indicative of worker status, we say, as its presence. As to the requirement for mutuality in EU law, can I ask, please, that Allenby is turned up again. This is volume 2, tab 25 of the authorities, MS 319. Come back to Allenby, but just for present purposes, so tab 25, volume 2, and please, if I can ask the court to turn up page 351, MS 351, internal numbering 1360. Paragraph 72, in the case of teachers who are vis-a-vis an intermediary undertaking under an obligation to undertake an assignment at a college, it is necessary in particular to consider the extent of any limitation on their freedom to choose timetable and the place and content of their work. So when they're undertaking an assignment, necessary to look at those features. And then the paragraph goes on, the fact that no obligation is imposed on them to accept an assignment is of no consequence in that context. So the absence of an obligation, as a matter of EU law, is of no consequence.
The context being?
Assignments to undertake teaching.
No, the context, I assume that the reference to in that context is the context of whatever the issue is.
The issue being whether or not they are formally classified as, if one looks at paragraph 71, forgive me, paragraph 71, are they
A worker, are they?
a worker, or is the degree of independence? So the question, the Allenby question, which I will have to come back to in due course, but are they workers or not? Looking at the degree of control during the currency of the assignment, but as between assignments, the absence of mutuality is of no consequence. So we say that whilst Lord Justice Underhill has said that mutuality of obligation between assignments, or the absence of it, is significant for determining status during the currency of any assignment, we say not so in EU law, from where the working time regulations derive, as of course the Equality Act, and just as indicative of worker status as non-worker status. Finally, on EU law in the context of the working time regulations, I'm still here dealing with the LIM-B worker, which is, as I've indicated, equally applicable in the context of the working time regulations. So an EU case, please, if I can ask you please to turn up tab 3 of the supplementary authorities bundle. I hope you have the supplementary authorities bundle.
Do we have it electronically as well?
Well, they found it.
I don't think so. Is it electronically? Is it electronic?
Yes, I think they probably.
No, I'm afraid I don't think so. Did your ladyship have the hard copy?
I have the hard copy, yes. I'm just hoping I've got the other sort. Yes, I have.
Oh, perfect. So this is Fennell, a Court of Justice case. It concerned working time. We see that in the head note. Facts. It concerned the working time regulations. The worker was a disabled person who was employed in what we used to call, in the old days, sheltered employment. So, working in a centre which provided rehabilitation opportunities, educational support, and medico-social support. He claimed to be a worker, and as to the test for determining whether he was or he was not, if I can ask you please to turn up paragraph 27 of the judgment. So if you please go to MS number page 53, or internal numbering 75, because the first paragraphs are those of the Advocate General in the normal way. So the court's judgment, relevant parts of the court's judgment, MS number 53, paragraph 27, perhaps start at 26 just to contextualise it. 26, as the Advocate General pointed out, that finding applies with regard to the interpretation of the term worker, that's so looking at the term worker, within the meaning of the directive and the Charter, in order that the uniform scope of the right of workers to be paid leave may be ensured. I won't try and pronounce the Latin, sorry, I know that's...
Well, that finding is that it's got an autonomous meaning.
It's got an autonomous meaning.
Yeah.
And as to that, sorry.
Well, yes, and the last half dozen lines of paragraph 27 are the mantra, the standard statement of worker status in virtually all the European cases, aren't they?
Virtually all the European cases, but a very wide meaning. So it's an autonomous meaning. It's an autonomous meaning. We don't get anything about clients or customers or anything of that sort. Mindful I can't go behind X, Givrage and Bates, but if I may just observe, paragraph 27, in that context, it should be recalled that according to settled law, term worker within the working time regulations, working time directive, must it be defined in accordance with objective criteria that distinguish the employment relationship by reference to the rights and duties of the person concerned. So any person who pursues real, genuine activities to the exclusion of activities on such a small scale as to be regarded as purely marginal and ancillary must be regarded as a worker. The essential feature of an employment relationship is that for a certain period of time, a person performs services for and under the direction of another person in return for remuneration. So a wide reach, unsurprising, given the importance of the Working Time Directive, as I've indicated, it's a health and safety directive, and no basis for limiting it any further so far as the working time regulations are concerned, beyond the meaning afforded by this case, which is a recent case, 2016. So not an old case, not overtaken by anything since. And of course, postdates Allenby. As then pleased to the Equality Act, just in short summary, recognising that we can't go behind the cases I've identified, and as I hope was clear from the case, we do urge upon the court caution, very respectfully, because the bar in relation to worker status in our submission is ever increasing. So mutuality of obligation dwindle, not seen anywhere else, not seen in EU law. Client-customer, not seen in the Equality Act. Broad concept of worker given under the under EU law, autonomous meaning, as we've just seen. But hurdles, we say, implicitly being introduced, which raise the bar. And in our respectful submission, we say that caution needs to be taken to ensure that it isn't raised even higher than it already is. As to the relevant EU law, if I could look at the directive, because it is so important, this is the Equality Directive, tab 7, volume 1. MS 29, MS page 29. The recitals, of course, in the ordinary way, contextualise the directive. At recital 3, referring to Article 3 of the treaty, one of the aims of the community at that point being the elimination of inequalities, as well as the promotion of equality for women. At recital 4, a number of international instruments addressed, dealing with non-discrimination. Recital 6, emphasising the importance of combating discrimination in the workplace. Again, at recital 9, to similar effect. And recital 11, emphasising too, that discrimination connected with the protected characteristics may undermine the achievement of the community's aims. And then the particular provision, Article 3, the scope Within the limits of the areas of competence conferred, the directive shall apply to all persons as regards both the public and private sectors, including public bodies, in relation to conditions for access to employment, to self-employment or to occupation, including selection criteria and recruitment conditions, insofar as access to employment, self-employment and occupation is concerned. No distinction between those three classes being made. I appreciate that words have been implied in consequence of Allenby, but I just emphasise that the directive in terms has wide reach. The provision of the Equality Act itself, of course, as we know, in terms is broader, in terms appears to embrace a wider range of relationships than that contained within the Lim B definition, and we see that at MS page 20, behind tab 4. So 83.2, a contract personally to do work. Under a contract personally to do work, no reference to the status of clients or customers or anything of that sort, but reflecting the broad meaning provided for under the directive. As to Hashwani, if I can ask please that the court turn up volume 2, tab 36, MS 500. At 512, so MS 512, internal numbering 1016, looking at Allenby, page 512, the MS number, 1016, the internal report number, and this is an extract from Allenby. In fact, starting at paragraph 62, if I may, so the page before, 511, MS 511, extract from Allenby. The criterion on which Article 141 is based is the comparability of the work done by workers of each sex. Accordingly, for the purpose of the comparison provided for by Article 141, only women and men who are workers within the meaning of that article can be taken into consideration. There needs to be a context for comparability. In that connection, it must be pointed out that there's no single definition of worker in community law. It varies according to the area in which the definition is to be applied. We know what the definition is in relation to the working time regulations. We've seen it. But here, in Allenby, the court was clear that when one looks at the meaning of worker, one looks at it in context, and at paragraph 68, making clear that the context for their determination was the fact that this was a 141 equal pay claim. Pursuant to the first paragraph of Article 141, for the purpose of that article, pay means the ordinary basic or minimum wage or salary or any other consideration, whether in cash or kind, which the worker receives directly or indirectly in respect of his employment from the worker. It's clear from that definition that the authors of the treaty did not intend the term worker within the meaning of Article 146, should not include providers of service who are not in a relationship of subordination with persons who receive the service. So there is a comparability, a source for the inequality in pay that must be assessed as between men and women. So although, of course, this court has held on more than one occasion that the effect of Allenby is to impose the same threshold as seen in the context of Limb B workers. That is, the customer, you mustn't be servicing or providing work to a customer client. We do say that has to be looked at with some circumspection and certainly not unduly narrowly. And again, as I've already indicated in the context of the ERA, there's nothing in any of the authorities from the EU indicating that mutuality of obligation is relevant. And perhaps just two more cases, if I may, from the EU. Firstly, Canston, which I think you already looked at briefly, but if I may just go back to it. Volume 2 of the authorities, tab 38. This was the collective agreement case. So the question was whether or not those musicians were independent contractors or employees, workers. If I can ask, please, that the court turn up MS 54551. Paragraph 33. As far as concerns the case in the main proceedings, it must be recalled that according to settled case law, on the one hand, a service provider can lose his status of an independent trader and hence of an undertaking if he does not determine independently his own conduct on the market. I emphasise that when we come back to see what the terms and conditions of the arrangement were in this case, because independently his own conduct on the market, but is entirely dependent on the principal because he does not bear financial or commercial risks arising out of the employer's activity and operates as an auxiliary within the principal's undertaking. So within the principal's undertaking. And then 34, on the other hand, the term employee for the purpose of EU law must be defined according to objective criteria that characterise the employment relationship, taking into consideration the rights and responsibilities of the person concerned. Settled case law that the essential feature of the relationship, the essential feature is that for a certain period of time, one person performs services for or under the direction of another in return for remuneration. And of course, paragraph 35, the label of self-employment isn't an answer. So, similar to the sheltered employment case, for now, one's looking at work under the direction of another and payment, a wide reach. And then, please, if I can turn to Denosa, at tab 32, MS 450. This was a director of a company. The question was whether or not she could be an employee as well as, or a worker, as well as a director of a company, the company with whom she worked. If I can ask, please, that the court turn up paragraph 49. Which is at, forgive me, thank you, MS 458, thank you. Looking first at the degree of freedom, 49, the fact that Ms. Denosa enjoyed a margin of discretion in the performance of her duties. She had to report to her manager, to the supervisory board, and to cooperate with that board. So just picking up on one of the issues the court was considering, the fact that Ms. Denoza had a good deal of discretion about how she worked didn't affect the fact that she could be a worker for the purposes of EU law. And at paragraph 56, picking that up again, and this is the Pregnant Workers Directive. Again, the significance of the Pregnant Workers Directive, both as an equality directive and a health and safety directive, can't be overstated. Paragraph 56, in view of the foregoing consideration, the reply to the first question is that a member of a capital company's board of directors who provides services to that company and is an integral part of it, again, I flag integral, must be regarded as having the status of worker for the purposes of Directive 92/85 if that activity is carried out for some time under the direction or supervision of another body of that company, and if in return the board member receives remuneration. So EU law, broad context of broad concept of worker, forgive me, I'm not being very articulate at the moment, I think it's late in the day, I'm sorry. Broad concept of worker, particularly in those areas that are highly protected, outside of equal pay, one's looking for direction in return for remuneration. So we say, whilst we can't go behind the cases to which you've already been referred, we do say that they ought to be read in context, that is, in general terms, a wide reach must be given to the concept of worker status. I'm going now to turn to the facts. I wondered, my lady, if, although it's 7 minutes beforehand, if I take 7 minutes off my time, whether it might be convenient to finish a little earlier so I can deal with it perhaps more expeditiously, given that we've seen some of it.
If that suits you,
It suits me, and I will
you are
not take
offering
any
to
more.
take 7 minutes off
I
your
will
allotted
take 7
time.
minutes. I can do that.
Well, that is a matter for you, Miss Monaghan.
Yes, thank you.
So, well, we'll look forward to hearing from you further at 10:30 tomorrow morning, and the court will now adjourn.